Hello and welcome to our today's Coffee and Consulting. We have a great guest today. Benjamin Kranc is from Canada today with us, and we will talk today about Canadian immigration and that Canada is not the 51st state of the U.S. Um, Before we start, my name is Frederike Ruch. I'm just really at the beginning telling you a couple of things, introducing also Benjamin to you, and then I will hand over to the stage to Benjamin because he's the expert and he will then enlighten us in everything about the Canadian immigration. In the end, there will be time then for all of your questions, so please write them down in the question box as usual, and we will then answer them just directly after the presentation. And Benjamin will have about 30 minutes to tell us a bit more about the Canadian immigration system. Benjamin, if you can switch maybe to the next page. Just before we start, Canada is quite important also from us, even if it's far, far away. They have a couple of global good ranking. I have looked it up over the last week and saw you are tens of global provider. Oil reserves is quite something. Third place in global ranking. Uranium production, forest production. So there is quite a lot we actually have trading with or global business with. And there's also on top of it with the EU and trading agreement, the CETA. So there is a lot, and I think a lot of people going from the EU or Switzerland to Canada, as well as a bit also vice versa. But today we focus on the Canadian immigration system. If you can switch to the next slide, please. And we have, as said, Benjamin with us. He is the founder and principal lawyer at Kranc Associates in Toronto. He is a certified specialist. He is really the person you can ask any question about Canadian immigration law, and he can very well describe you and explain it to you. He has a lot of publications, a lot of teaching parts, and is a very recognized leading practitioner in corporate immigration by who's who in the legal world. So he is definitely the person to speak to when it is about immigration law. With that, Benjamin, I will hand over to you, and we are happy to listen to you.
Okay, just to make sure you can hear me and see the slides, is that correct?
Yes,
And
perfect.
see me, I hope as
Mhm.
well. Like,
Yeah,
yes, okay,
super.
thank you for the introduction. We have very limited time, so I do want to move relatively quickly. Just to note, my last name is actually pronounced Kranc. It's a German word with Polish spelling, so long story in my family. But in any event, yes, we're going to talk a bit today about Canadian immigration. And we often hear, obviously we are closely connected geographically and otherwise economically as well with the United States. We often hear about people saying, well, I'm going to the United States on an L1 or an H1B, or they have their various categories. But our system is completely different. And part of my purpose today is to make sure that people do recognize the difference, and that hopefully you can get a general understanding of the Canadian system and get an overview. Obviously, in the limited time, we cannot cover every aspect, but hopefully you will see the big picture, and then if necessary, you can drill down in any particular matter. So just to start, I think it's useful sometimes to understand some of the terminology that people throw around before you get into a system, and that way you can sort of deal with people on a level where everybody understands each other. Our main legislation is called the Immigration and Refugee Protection Act. Our immigration department is IRCC, Immigration, Refugees and Citizenship Canada. Even though we call that the Immigration Department, it's actually divided into a few departments, and the next one is the Canada Border Service Agency that deals more with enforcement and border control. But if you were to fly to Canada to seek a work permit, you would be dealing with a CBSA officer on arrival. ESDC, Employment and Social Development Canada, is basically, for our purposes, again, it's a bit of a longer story for this, but it is our labor department, and they set policies about foreign workers and when we can bring them and not. And obviously, we'll be talking about some of that. But they don't do their own work. They send it to another department called Service Canada that actually deals with these issues. And that program to bring in foreign workers is called the Temporary Foreign Worker Program. And if you are seeking a temporary foreign worker, subject to exceptions, which we're going to get into, you will be seeking a labor market impact assessment. That is the tool, the legal tool to get a foreign worker to Canada, the primary legal tool anyway. NOCs are the National Occupational Classification. Every job for which someone is coming to work in Canada has a NOC code, and those codes are very important. They do have implications about salaries and spouses working and all kinds of things. So you do have to be careful in any application with those. IMPs are the programs that are exemptions from the LMIAs, and we're going to talk about those. Visa application centers, almost all applications these days that do need to be filed online. Not all of them do need to file online, but for those that do, they are filed through the Canadian government portal and website. But when you need to actually deal with embassies, these days we kind of deal through middlemen called the Visa Application Center, and they are located in various centers around the world. Foreign nationals are basically anybody who is not a permanent resident or citizen of Canada, because if they already are, then usually they're not someone that comes to us for assistance. ETAs are electronic travel authorizations. If you don't need a visa, which is true for most Europeans, then you do need these days something called an ETA, which kind of screens you before you are allowed to board an airplane. And we do have various free trade agreements, which we're going to get into, and we just call those FTAs in general. So basically, the entire immigration scheme from the point of view of work permits and corporate immigration is on this slide. Yes, we do have plenty of other immigration issues in terms of family-based and entrepreneurs and what we call economic class, permanent residents, various other things. But in terms of coming temporarily for work or business visitation, this is the system. And the system is that if you want to come work in Canada, the employer first needs to get an LMIA, Labor Market Impact Assessment, as we discussed, to prove that they couldn't find a Canadian to do the job. And we're going to discuss details of that in one moment. But there are many exceptions and exemptions from the LMIAs, and often we are trying to find one of those exceptions because it'll make life easier for everyone. So one of the most common is intracompany transfer and various free trade agreement professionals, and again, we'll get into those. But also, sometimes you can come to Canada and you don't need a work permit at all. You're coming as, for instance, a business visitor. But I will say, and we're going to talk about this too, that this is taken for granted often because people say, oh, I'm just coming as a business visitor. Well, you've decided you're a business visitor, but you have to see what the law thinks. And from an immigration officer's point of view, you're usually swimming against the stream, meaning that they're going to assume that you're coming to work unless you can substantiate that you are a business visitor. And even though it often seems routine, it is perhaps one of the more difficult things in Canadian immigration. And then on top of all this, so again, that is the basic system. Either you need an LMIA and work permit, or just a work permit, or no work permit. But on top of that, we do have compliance issues, which we'll briefly touch on. So as we mentioned, there's the LMIA. If this is paraphrasing our regulations about what an officer looks at Service Canada to decide if a company will be allowed to bring in a foreign worker. As you can see, there are actually, I guess it's six and a half sort of conditions. But you'll see as well that C and D I've marked with an asterisk because the reality is that without those two factors, you're not getting an LMIA. You have to show that the work is likely to fill a labor shortage, meaning that there's no Canadian to do the job, and that you're paying appropriate wages. Without those, again, you're not getting an LMIA. And to note again, this is an application by the employer, not the employee, even though often when we're dealing with files, we say, with the LMIA for Mr. Smith, but that's not really correct. It's for the company that wants to hire Mr. Smith. So just touching on some of the issues within an LMIA, before the government will grant one, you have to do a few things. You have to advertise on various recruitment sites for 4 weeks in the last 3 months. You have to do that in 3 places. 2 of them are sort of general websites where people might often look for work, plus one other website, which is essentially a government-run employment website. And that one has to keep running even after the 4 weeks is over. Because again, the point is to try to hire a Canadian. So if a Canadian pops up during the process, you still do want to um, you do have to be able to show the government that you are continuing to try and find a Canadian. The filing fee is 1,000 Canadian dollars per position. I don't know what that is in euros these days, but in US dollars, that's about $700. And there are different types of LMIAs, those for high wage and low wage. And here's already one spot where you have to know the knock. It depends on the knock that will tell you the average wage for a particular job in a particular province. And we do have to go province by province. And if you're above that wage and that knock, you will have to, there's one type of LMIA, and otherwise there's another type of LMIA. Usually we're dealing with the high wage, but it depends, of course, on your business. And when you are dealing with the high wage, you have to do something called a transition plan to show that you'll try and find a Canadian to fill this position down the road, because after all, this is supposed to be a temporary position. That being said, the transition plan often is, and this is legitimate, to say that we're going to turn this foreign worker into a permanent resident as soon as we can. And that often works. So that's one thing to keep in mind. And finally, in terms of LMIAs, there are some subcategories where the conditions are changed a bit. Most commonly or most importantly is the global talent stream, where the government says that we are going to bypass the recruitment. We're going to assume that there are shortages in these jobs. And if you look at category B there, I've given a few examples of the types of jobs they say. They're typically IT related jobs, but there are a few others. There are 13, I believe, on the list at the moment. But so the government says you don't have to recruit because we know there's a labor shortage. However, what companies often don't realize is that there's a back end to this, because you need to show the government that you will give Canada 3 benefits, that you're going to increase investment in training, and then that's mandatory, and then 2 others, things like increasing diversity, hiring more Canadians, increasing revenue, various things like this. So it is a good program, but it's not just a walk in the park. Even though your recruitment is bypassed, you still have these obligations. And there are some other initiatives to allow people. It used to be, you're coming, as I mentioned, the distinction between business visitor and worker is not always that clear, but sometimes you're still coming for a brief visit, but you are working. So the government allows in the higher knocks, yet again, we have to worry about knock. Knock 0 or 1 means 0 are management level and 1 are university level positions. Those people, if they're coming just for a very brief period, they might be able to come on a work permit without an LMIA and not as business visitors. And it's important to recognize, though, that you can only use this either once every 6 months or once every year. And so if you try and come later as a business visitor, you might have a problem because there'll be a conflict. But if you don't have that issue, it is a good way to try to come to Canada to work if necessary. So again, that was the LMIA scheme. And I know I'm going quickly, but again, we have limited time. Now we're going to talk about the exemptions from the LMIA. And the most common, as I mentioned, is the intra-company transfer. So this allows corporations with offices in Canada and in another country to transfer personnel. But there are conditions to this. It is not just a walk in the park either. First of all, there has to be, the affiliation has to be shown. And the government has issued some stricter guidelines about what kind of companies will be allowed to do this. Sometimes you have to have for a new company in Canada, you'd have to have existing operations already in 2 other countries, things like this. So it depends. It's not something, again, to be taken for granted. The person has to have worked there for at least 1 in the last 3 years, and the person needs to be currently working there, which you might think is no big deal, and often it's not. But sometimes what happens is so-and-so retires, And he says, but I'd still like to work. And they say, okay, we'll ship you off to Canada for a while. But that causes issues with insurance and seniority and unions and all kinds of things. So again, not something to take for granted. But most importantly, I would say you have to look at the type of job. It's not just any job. It has to be either an executive or senior manager. That's usually managing people, not functions. There can be exceptions, but generally speaking. And specialized knowledge. Specialized knowledge means advanced experience and proprietary knowledge. By the way, that used to be either or. Now it's both in the last few years. So it's not just anybody. And I often tell people, you can be the most brilliant nuclear physicist in the world, but if you don't have proprietary knowledge about your company's stuff, you're not getting a work permit. So again, you have to make sure all those bases are covered. And the legal source for intercompany transfers actually comes from different sources. The actual regulations plus some of these free trade agreements. Now, overall, these are pretty much the same these days, but there are some divergences, so you have to know where the person is coming from. And that includes from the EU, which we'll touch on in a moment. On top of the intracompany transfers, we do have some other categories, such as these professionals I mentioned, which we'll talk about in 1 second, and some other categories. And these actually, some of these categories come and go. So you do have to keep up and be aware that there might be other possibilities at times. In terms of professionals, these are the various types. As you can see, I've kind of color coded these. Starting with the purple group on the left, these are kind of the old-fashioned agreements. There's nothing wrong with them, and they're still in use, except that speaking of the 51st state, Mr. Trump isn't always so receptive to CUSMA, which used to be NAFTA. But in any event, the point of these, for our purposes, is that under these various agreements for U.S., Mexico, Chile, Colombia, and Peru, we have systems where we slot professionals. Basically, you have to fit on a list, and it depends on whether your job fits on that list, or in some cases, such as for Colombia and Peru, they have a negative list. In other words, you can come unless you're on the particular excluded list. But it's still the same idea of pigeonholing various professionals. On the right, in black, we have various free trade agreements that are kind of the newer versions where they don't pigeonhole occupations. They just look at the nature of the service, kind of. And as you'll see, obviously, for the purposes of people in Europe, the most important might be CETA, the Canada-European Union Free Trade Agreement, which allows for contractual service providers and independent professionals. You'll notice that there's a separate agreement for the UK. That is actually identical to the European Union one, but of course, the UK left the European Union, so that's why it's separate. And finally, by the way, the CPTPP, which is a mouthful, is for various Pacific Rim countries, and we'll discuss that in a moment as well. But that the United States is not part of that. They were supposed to be, and Donald Trump pulled out the first time around, so we were left with all these other countries who continued on. And finally, we have GATS, the red one, which is not really the same kind of agreement. It's an international instrument, and it is the cousin of the better known GATT, General Agreement on Trade and Tariffs. This is the General Agreement on Trade and Services, where they also have various occupations. It's a more limited group of occupations, and it's only good for 3 months in any 1 year period. So you might ask me, why would I want that? Well, first of all, maybe you do only need a brief period, and second of all, sometimes we use it to bridge an LMIA. We get a person here quickly, and then in the background we're working on an LMIA. So as I mentioned, there's a CETA and the UK version of that free trade agreement, and we have situations where people are EU or UK service suppliers and are able to come to Canada to service clients in Canada. This is basically what it boils down to. If you're coming as a contractual service supplier, you need at least 3 years of experience, and as an independent professional, 6 years of experience. And as you can see, I said the jobs are not pigeonholed, which is correct, but it's usually that you need a university degree and, if applicable, the licensing. I will briefly mention CUSMA, which is the North American version. I know I'm speaking to a European audience, but certainly in Canada, I would say the bulk of our professionals are coming from the US, and they have various occupations listed, such as them. You can see some samples there: engineers, architects, etc. Some of these have details to worry about as well, but we won't get into it right now. But in any event, for North Americans, this is the primary tool. I didn't list out the CPTPP details, but to know that I'm going to go back 2 slides here quickly. It is more or less the same as this. The only difference is that they allow for um, occupations which are lower down, which are technical skills that might have only 2-year degrees, things like that. And the countries that are on the list are, again, various Pacific Rim countries, including um, uh, Australia, New Zealand, Japan, Brunei, I believe, is on the list, and a number of others. So if you are in the Pacific Rim country, certainly we can take advantage of that. As I mentioned, there are other IMP categories. One of them is reciprocal benefit, and this is actually, I would suggest to you, underutilized. The idea, again, all this stuff we're talking about, is actually designed to protect the Canadian labor market. We're trying to avoid bringing in foreign workers, and we, as immigration counsel or assisting companies and people like yourselves and your clients to get people, are kind of swimming against the stream to show that we have to override that. And the government has come up with a policy that, you know what, if there is if a company is giving, or country, actually, country or company is giving Canada the opportunity to have Canadians work in that country or company, we're going to reciprocate, because it kind of balances out. So there's the formal programs, such as the various working holiday kinds of programs that do exist with various European Union countries for certain age groups, which are, we can use them where relevant, but they're a bit hard to plan for, because it's a system where you go into a pool and you might be selected and there are quotas and things like that. So it's not really so useful for the corporate world. Here and there, but overall not. But more importantly, we use a kind of uh, more dedicated version of this for the reciprocal benefit of individual companies, where there's an international company and they send people from Canada to any other country, and now they want to bring in people from another country, you're good to go. And I shouldn't make it sound so easy. There are plenty of details there too, but you don't have to send to and from the same country, and it doesn't have to be exactly one for one, but obviously it all has to sort of be reasonable. There's another program called the Francophone Mobility Program, which is sometimes sounds like it's too good to be true, but basically for a uh, they've changed it. It used to be higher level NOCs, but from almost any NOC now, if you're coming to work with a company and you're working outside of the province of Quebec and you speak French, we can get you a work permit under this program. Now, there are various government policy considerations here. Canada wants to sort of promote bilingualism, etc. But for our purposes, it doesn't really matter. We just want to make sure that we can take advantage of a tool that allows us to bring companies to Canada if necessary. And just a few others. Significant benefit actually is something that allows for any reason to argue to an officer that you should be able to come. Obviously, it's an override to the system and it's used with great discretion. You can't just use it every day, but if there's some emergency or something, you might argue that you should be able to bypass an LMIA. We often say at our office that the way to get a significant benefit work permit is to show that without the worker, we would have significant detriment, that something would happen, we'd have to shut down the plant or something like that would happen. There are also non-LMIA work permits for emergency repair, where the company doesn't have a Canadian presence. This is also, I mean, it's probably about 10 years, but it didn't used to exist. You used to have to get an LMIA for that. And various programs come and go, as I mentioned, but you have to sort of be aware of what might be applicable or available, and see if there's something that might be usable as a tool in any particular case. Again, I know I'm going fast, but there are some new initiatives. The government has actually a permanent residence visa called a startup, but they're allowing this to sort of be utilized as a tool to get a work permit in advance. So that's why I've added it to this program. So sometimes it's a useful way to get things up and running faster. And the government is also allowing now for companies to sort of have their, I guess you can call it a personal LMIA exemption, that you can say that we are an innovative company and please allow us to bypass the LMIA. And there are a few companies that have been granted this designation, not too many, but as time goes on, perhaps it'll grow. And the government now allows for digital nomads, which in my mind is a glorified business visitor, but nonetheless, it allows people to come work in Canada remotely for other countries. Just to note as well that I mentioned, I sort of didn't put this in the LMIA section. I left it for here because this is an LMIA program, but it is an exception in the sense that companies are also able to get LMIA exemptions on a sort of personalized basis if they've been getting LMIAs in the past, if they've gotten at least 3 LMIAs in the past 5 years. So we've discussed the fact that the starting point is you need an LMIA and a work permit to be able to work in Canada. Sometimes you're able to get the work permit without an LMIA, but sometimes you're just coming to quote unquote visit as a business visitor. Well, what does that really mean? First of all, according to the definition in the law, business visitor doesn't mean you're not working. It just means you're working under in a situation that doesn't require a work permit. So there are some pigeonholed categories here. There's about 30 of them probably, but just a few examples are clergy, journalists covering Canadian events, and certain athletes and entertainers. But on top of that, there is the uh, general business visitor category that allows for people to come and carry out certain activities that are supposed to be not entering the Canadian labor market. And some examples are usually things like buying Canadian products or receiving training, intercompany training, not the same as intercompany transfer, and selling not to the general public. Meetings as well. A lot of people say, I'm just coming for a meeting. Maybe, but please recognize that sometimes someone's job is meetings. So you can't take that for granted. So again, you do have to think about it. Your remuneration must remain abroad. A lot of people tell me, well, I'm still getting paid outside Canada. Yes, that must be true, but the fact that that is true doesn't mean that you're automatically a business visitor. You still have to meet the other conditions, and you must sort of still have your job back home. And hopefully you can show that it's really for the benefit of the foreign company more than the Canadian company that you're coming. Once again, I'm going quickly and there's a lot more detail, but I'm hopeful that people are just getting the sense of things you need to think about when you're dealing with Canadian immigration. So on top of all that, just to be aware, there are some um, issues of criminal inadmissibility, and people are often surprised to learn how strict Canada is on this. And more certainly stricter than the United States. We almost any foreign offense is caught, and again, we don't have time for all the detail, but the Canada divides crimes into two types: indictable and summary, which is kind of like in the United States, if people are familiar with felonies and misdemeanors. I don't know in Europe if there's in various countries if they have similar divisions, but it's sort of the more serious and the less serious. The issue in immigration law is that in the criminal law context, where the law says that a prosecutor can prosecute a case as either the more serious or the less serious, the immigration law will consider that crime the more serious no matter what, even if the prosecutor would have processed it in the less serious system. I hope that's clear, but yet again, there's the indictable more serious, the summary less serious, and if it's able to be processed as one or the other in criminal law, which is possible, they have these hybrids, immigration law will take that to be the more serious, and then therefore you're caught in terms of inadmissibility. Um, to be aware as well that DUIs, driving under the influence, and there are different in the United States. We see most of these types of things, but from whatever country you happen to be from, if there's some drinking and driving offense, whatever the nature of that is in the home country, it's we compare it to the how it's dealt with in the Canadian system, and it is seen as a serious criminal matter, which means that it's even more so than what we just discussed, that you're not able to override it automatically, which in some cases you can. So how do you override criminal problems? Well, first of all, you can get what's called a temporary resident permit, which means that the government, you can try to persuade the government that, okay, it was a one-time incident, it was long ago, I need to come to Canada, etc., and they might grant that. Or you can get rehabilitation, which is basically a permanent version of that, and you can apply after 5 years or be deemed rehabilitated after 10 years if it's one offense and it's and at least 10 years have passed and it's not punishable more than 10 years, which would make it the serious criminality. That's what I was getting at. So again, I know this is a lot of information here, but the point is that if you have a crime, you're going to be caught. If to get over it, you need a TRP or rehabilitation. And in terms of rehabilitation, it's deemed you can get it automatically after 10 years unless it's serious criminality, which will include DUIs after 2018. Also, cannabis is legal in Canada, but that doesn't mean you can bring it in, and that doesn't mean that it's a complete free-for-all. There are still certain specific crimes, such as having more than 30 grams in public. So that would still be caught. I just want to briefly mention some procedural considerations. Everything we've talked about so far is the substance, whether you're applying at a visa post online or whether you're applying at the port of entry. Those things all are the same issues. But how do you go about getting the documentation you need? Well, first we have to divide the world into those that need a visa and those that don't. So if you do need a visa, for instance, as you can see some samples there, India, China, etc., then your application is made online through a visa post and you have to file all the documentation there. If you don't need a visa, such as US, UK, all various other European countries, of course, etc., then you can apply when you arrive at the airport, which sounds like a benefit, but not always, because then you don't know what's going to happen until you show up. And one thing I will mention, we talked about ETAs, which is you see here on the screen as well, that you need an ETA to fly to Canada, even if you don't need a visa. And a lot of people say, well, I got my ETA, so I'm good to go. No, an ETA gets you on the airplane. It does not get you off the airplane because it's really just checking for things like criminality, etc. But if you're applying for, let's say, an intercompany transfer, you still have to make the case when you arrive that you meet all the qualifications. If not, you could be sent back. And I just will mention one thing, that to mitigate that port of entry risk, what we sometimes do is file what we call a pre-screen, which means that there's an office of the government called the IMWU, International Mobility Worker Unit, where we can file all the documentation in advance and get an opinion as to whether this will qualify as a non-LMIA work permit for a non-visa situation. So usually it takes a week or two. Most clients are in a rush, but if you have the time, we often suggest this. So I hope that's clear, but the basic idea is you do have to think about the procedure as well, and not just the substance. Where do you apply? How do you apply? How do you mitigate the risk? All those kinds of things. And finally, just to briefly mention, and this is more usually for Canadian companies that are bringing in workers, but even foreign companies might be the company that's sort of on record as bringing the foreign worker to Canada. You have to maintain various compliance issues, such as, first of all, complying with what you said you would do, such as paying the appropriate wages, etc. Also, complying with any other legal requirements, such as the employment standards in Canada is province by province, but we have things like, workplace that's free from harassment and all those kinds of things. And you also have to maintain records for 6 years. And if there's an audit, you have to be able to produce the records and show that you complied with everything you're supposed to. And we do see a lot of audits, so you cannot take this for granted. But this is something that has come up in the last few years, and we can't just celebrate when somebody gets a work permit. We also have to think, still continue to work on that person for about 6 years until everything is settled. But in any event, there is this employer compliance element. So in summary, Canada is open for work purposes and foreign workers and business visitors, etc. But there are certainly issues to consider. There are obstacles and there are opportunities. First of all, please do consider where you need to apply, whether it's you need a visa or you don't need a visa, and that will impact various considerations. The strategies that we talked about and the impediments. And of course, again, we've just touched the surface of some of these things, but I hope people have been able to see the issues that they need to think about. Of course, the purpose of travel, the inadmissibility issues, maybe everything else works, but your potential employee has a criminal record, then things might have to change, and all the compliance issues. Plus, of course, there are non-immigration issues such as tax. Tax is always an issue, right? And those don't always jive nicely. People often assume, well, if I get a work permit, then the tax considerations should all fall into place. No, not necessarily. There are various treaties, and you do have to think about that separately. And also, some of these people will want permanent residence, and that's a whole other session. So, but do keep in mind that some of the factors of getting a work permit may help in the permanent residence down the road. That is basically it. I will quit there. I hope that's been of value, and I hope I have enough time to take some questions. So, Frederica, if you want to tell me any questions, I'm happy to do that.
Thank you very much. It was great, very insightful, and I think to the audience, really the best information. And they can reach out to you directly. So if they have any questions afterwards and need some support in Canadian immigration work. Now we
Okay.
do have some questions. So the first one is: can a Swiss company send their employees to Canada to work from home? And if there is no office and no legal entity, is that still possible? And then for how long? And is there any kind of limitation nationality-wise of the employees?
Okay. That's a whole course in itself, that question. So, um, first of all, when you talk about remote work is a big issue these days.
Mm,
In terms of if you're working remotely for the foreign company, you could be a digital nomad, and yes, you can come to Canada perhaps and do your thing, and that's okay. By the way,
mm,
before they introduced this digital nomad, there were some questions like if you look at the definition of work in our law, just because you're working for the foreign company didn't automatically exempt you. But let's not get into all that.
mm,
For now, that's the case. However, if you are coming to work in Canada for, let's call it the benefit of Canada, even if it's not technically with the Canadian subsidiary or whatever it happens
mm.
to be, that may not be allowed because from
Okay.
the Canadian government's point of view, if you can do your work remotely, why should we give you a work permit? There's
Mm,
no need for that. So, which by the way may mean the whole immigration system is obsolete, but that's also a story for another day.
mm.
But I hope I've answered that question. I don't know if there was another component to the question.
For how long can
Oh,
someone work as a digital nomad?
okay. A digital nomad, any visitor to Canada gets an automatic 6 months unless the officer stamps something different. They might stamp shorter or longer depending on the situation. But if you want longer, you'd have to convince them why you're hanging around for a year to work for your company back home in Europe. It might not be always that obvious.
Maybe because Canada is very nice and it's nicer than back home. So,
Maybe. I'm going to tell you that often it's because there's somebody has a boyfriend or girlfriend or something like that. But
mm, true. Then we go to business trips. So, if you have employees travel to Canada for business trips, do they need a visa or work permit? And how can that be explained the best at the port of entry or wherever?
yes, as I mentioned, this is a difficult issue. It sounds like it should be easy, but not always. The dividing line between business visitor and worker is not always clear. We have to see case by case, but the main issue is, are you entering the Canadian labor market? And
Mm,
you want to be able to show that you're not, that perhaps you're coming just to meet with a client or get some training or whatever it is, and not taking
mm,
a Canadian opportunity. Those are the real wishes they want. And it is important to document these things. You want letters from the sending company or receiving company or both, or, it depends on the particular situation. And also it depends where you're coming from. If you don't need a visa, then this is done at the port of entry. If you do need a visa, it's done online through the consulate.
mm. Okay, thank you. Then, can the accompanying spouse also work or study, or are there any limitations?
Again, this sometimes depends on the knock, as I mentioned, but
Mhm.
the answer for a worker is that usually the spouse can work they get an open work permit. There are limitations in the sense that if you want to work in a medical field or with children, things like that, you have to take a medical exam, but it's still uh, not doesn't change the fact that that the spouse is entitled to work, um, as long as the principal applicant, actually the principal applicant needs a work permit for at least 6 months, but otherwise, basically yes. I'm sorry,
Mm.
that maybe there was another component to that question too.
No,
No,
I
okay,
think that that was
okay,
the major part was about whether the spouse is
yes,
working as well, because in some countries that's not possible. So,
yes, it is generally possible in Canada.
mm. Is there always a
I'm
legal
sorry,
entity?
sorry. The person asked about studying. That was the other part. Studying is not allowed unless you get a separate study permit. Okay, sorry, go ahead.
Okay, but if someone is enrolled in an at an university in Canada, then there's no problem at all. Or is there one
For you mean as can a student
as the
work? Is that
spouse? Yeah.
no? Yeah, well,
Ah.
no, that depends. That's a complicated thing. If someone is
Mm.
studying at a Canadian school, whether or not the spouse can get a work permit depends on the type
Mhm.
of program and various
Okay.
other things.
Okay. So then better to check in with you again.
Yeah. Okay.
Is an employer legal entity in Canada required as a sponsor for the work permit?
Uh, Technically, I would say no, but it creates some complications. It depends. We do have situations where it's just a foreign employer who has somebody who needs to work in Canada, and sometimes there's I would call a hybrid of that in the sense that there's a company with a Canadian branch and a foreign branch, and the person remains on the foreign payroll and like they're still connected with the foreign company, but they're working in Canada. That can be sort of sponsored by the foreign company. It's a longer story, but the safest answer is you should have a Canadian entity. You might
Okay.
be able to get away without it, but it makes things complicated. It depends on the
Mm.
case.
Do you, and that is a personal question, if some of the companies are tending to use those employer of records?
Yeah, that's a problem because
Okay.
um,
Mm.
there are the Canadian government. The general policy is yet again you're coming to Canada because presumably you're needed. There's a reason we're not hiring a Canadian, but an employer of record kind of means that often that somebody's coming and then that employer farms that person out to another company or whatever. So you
Mm.
didn't prove that you need this person in Canada.
Mm.
So again, every case has to be looked at uniquely, but I'd say the general rule is that employers of record is not a good way to go.
Mm. Yeah, we have the same in Switzerland, so.
Okay.
Um, can someone also just work on a project basis on at the client side as a German national with a German employer?
The question comes back to the same question. Are they a business
Mm.
visitor or a worker? And if
Okay.
they're a worker, in what program do they qualify? So when you say a Canadian client site, that doesn't necessarily tell me. If they're working, and by the way, another business visitor subcategory is after sales service. So if your company sold a product to a Canadian company and you have to come show them, install it and show them how to use it, that might allow you to come do that. But you'd have to see case by case if you need a work
Yeah.
permit or not, etc.
Mm. Mm. Then one more question about the dependents. Which dependents can accompany the employee? Also parents, parents-in-law, sisters, brothers?
No, only spouses or partners and children
Mhm.
under the age of 21. Uh,
Okay.
the children gets a little complicated in the sense that you can bring them to the age of 21, but they can only study up to the age of 18. So if they're
Mm.
over 18, they can come as visitors, but usually that's a little bit of an issue.
Mm. We have the same in Switzerland. We only
Okay.
allow kids up to 18, and then otherwise they are on their own, basically,
Okay.
which is not very useful. But are there any registration requirements in Canada?
Well, yes, but first of all, if you are quote unquote sponsoring a work permit, whether that's
Mm-hmm.
LMIA based or not, you will have to register with the government. And the non-LMIA cases, we have to create a portal where the company files all
Mm-hmm.
kinds of stuff.
mm,
for this. Plus, there might be other registrations too, non-immigration registrations.
mm,
I'm just talking about the immigration registration.
mm. Okay, perfect. So the last question is a question from myself. We have in Switzerland a golden visa, which is basically something you people can pay a certain amount and then they get a permanent residency in Switzerland. We don't have a lot, but we have. Is that something Canada knows as well, or
Well, Canada has had, again, we didn't really talk about permanent residence today. That's a
yeah,
whole other topic. But
yeah,
we
true.
have investor programs. We don't have, I mean, I don't know what the requirements are for this golden visa, but we don't have anything that's just purely passive. It used to be that there was an investor program that was a federal program across the country, but now the only one left is the Quebec program that is kind of it's sort of semi-passive.
Mm,
And Honestly, I don't remember the details at this moment because we hardly
mm,
use it. I will tell you that Quebec program every year opens up and it closes within one day with all kinds of applicants, mostly from China, to tell you the truth. So
okay.
that
Mm,
kind of thing. But in the rest of the country, there are business permanent residence programs, often what we call entrepreneur programs. They're
mm,
often provincial based, where the province says if you
mm,
can come open a business and show us that you're hiring some Canadians, things like that,
mm,
that we will give you permanent residence. But there's no direct, like just pay for the visa kind of thing at the
mm.
moment, other than the Quebec one.
Yeah, we have that for some of the more popular people. Like one is Robbie Williams. It was just in the newspaper now. He pays apparently 500,000 Swiss francs a year, and for that he gets a permanent residency.
Hmm.
So
I think Tina Turner might have used that program too.
yeah,
I don't know.
I'm not quite sure. I mean, she's not any longer there, so
I know.
I don't know. Okay, thank you very much. That was all the questions we had for now. So, in case to the participants, in case there are any questions later on, you can either reach out directly to us or directly to Benjamin, and he will definitely support you as best as he can. Thank you very much, Benjamin, for being here today with us, and we hope to see you soon at one of our next events.
I'll be happy to
Thank you
help out again.
all.
Thank you. Bye bye.
Bye.
Bye bye.